Hello everyone, this is the Mass Analyst. This is the first in a series of 4 or 5 videos I plan to make discussing copyright law. What is the purpose of copyright law? What is fair use? How does the Digital Millennium Copyright Act affect fair use? And how has the DMCA been turned into a tool for censorship? These are a few of the questions that I'd like to explore in this next series of videos that I'll be making, I suspect, time permitting, over the next couple of weeks. Now, before I go on, let me give you a couple of caveats. First, I'm not a lawyer, so if you're even thinking about taking anything that I say as legal advice, do yourself a favor and consult with a real lawyer. Second, my past experience has somewhat prejudiced me, and I want to spell out my prejudices right now, get that out of the way before we go into anything of substance. Back in November, a user called the Red Skull, someone had released his personal information, and he responded by making a video in which he claimed that he was receiving death threats over the phone because of this. And he supposed, or he guessed, that he was receiving these death threats from Renetto fans or Boheme fans, possibly as a result of his not paying Renetto for a $1,000 bet he had made. Well, I saw this video and I looked at it, and it was totally illogical, and I could see that his claim for that he was receiving death threats was totally bogus. So I made a video response, and in that video response I took clips of his videos to show how what he was claiming could not possibly have happened. Well, he sent a DMCA notice complaint into YouTube, and as a result, YouTube removed the video in which I showed that he was lying when he was claiming that people were threatening to kill him. So YouTube removed the video, and the evidence was buried. Turns out later on that the Red Skull sent me a message admitting that this was indeed a lie and that I was indeed right in my assessment. But evidence of this incident has now disappeared down an Orwellian memory hole. So I'm somewhat biased against the DMCA. I have to admit that right now. Okay, now that I've gotten those caveats out of the way, I'd like to turn to the meat of today's discussion. I'm going to start out first by giving you a pop quiz. What do you think the purpose of copyright law is? Why was it invented? Now, if you said to protect the rights or the interests of the author in their works, to enable the person who creates the copyrighted work to have control over their works, well, you are wrong! Nope, that's not the purpose of copyright law. That's not the reason why we have copyright law. If you want to really know the reason behind copyright law, its whole reason for existence, one only needs to turn to Section 1, Article 8 of the Constitution. Article 1, Section 8 of the Constitution. And that says, the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now keep in mind, when this was written back in the 1700s, late 1700s, the word sciences meant more than what it means today. Back then, the word sciences meant general knowledge or learning. So the purpose of copyright law was to increase the knowledge and learning available to people, to further discoveries, or to invent new works of fiction that would inform people to various aspects of society or nature or the world in general. So the ends of copyright law, the whole purpose is not to enrich an artist, to give them control, but to increase knowledge, to make more works available that would help explain what's happened or explain the way the world works. So that's the ends. As a means to this ends, Congress has passed laws that would allow artists to have incentive to create new works, to allow them to profit from their works, and to control how their works are used. Now, it's a very fundamental misunderstanding to confuse the means and the ends. So always bear in mind when we discuss copyright laws that the purpose, the very soul, the reason for being of copyright laws is to increase knowledge. It's not to censor people, to prevent knowledge from being made public. It's to increase knowledge. And the method being used to increase knowledge, to create new works, is to give authors a monopolistic license over their works. So if you keep that in mind, then some confusion over copyright law will disappear. Now, if any of you need further evidence that I'm correct in my assessment, I'm posting a couple of excerpts from Fogerty versus Fantasy Incorporated. This is a Supreme Court decision in which they decided a couple of earlier decisions, and the citations back my claim that copyright law was intended to increase the general knowledge, to increase the number of works and the quality of works that are out there and available to the public, and not to enrich authors and not to give them control over their works. I'm also posting a link to a very informative article by Professor Lydia Loren. She's a professor of law at Lewis and Clark College, and what she's written has very heavily influenced me in this video. So I borrow very heavily from her. And I encourage all of you to go and read that article. Now, copyright law today is quite different from the way copyright law was first envisioned by the founders of our country. Back then, copyright law, the first Copyright Act was passed in 1790, and back then it only protected the creators of their works. It only allowed them to have a monopoly over the publication and distribution of their works. It did not give them a monopoly over the performance of their works, and it didn't give them a monopoly over derivative works that would be created from their works. For example, I could have taken a character from a work of fiction, an early work of fiction back then, and I could have used it to create my own work. Now today, under today's copyright laws, authors have control over derivative works, and they also control the rights to performances derived from their works. In addition, the original copyright law gave control, monopolistic control of the works to the creators for a maximum of 28 years. Today, that has been extended to 70 years beyond the death of the creator of the work. Why have copyright laws expanded so much? Well, I think you could sum it up in a couple of words. Greedy corporations. Now they'll argue that by expanding the length of the copyright laws and the interest of the copyright laws that the authors have in their works, that they create more incentive for artists to create more works. And there is some truth to that. Certainly, artists should be able to have control over the performance of their works. But is it really necessary to give an author an incentive to extend the law to protect their interests for 70 years beyond their deaths? Do any of you really believe that Stephen King would have written fewer books had copyright law protected his interest in his works for only 50 years after his death rather than 70? How about 30? If he only had his interest maintained in his works for 30 years beyond his death, do any of you think that he would have produced even one fewer book? It's hard to understand why it was really necessary for copyright law to be extended, for copyright protection to be extended so far beyond the author's death. The only people it benefits is the author's heirs, or more likely the giant corporations that have purchased the rights to the author's work. Now, Professor Loren wrote a very important paragraph that I want to read here, and I'll post it in the sidebar. She wrote, "In fulfilling the constitutionally mandated goal of copyright law, Congress has had to ask, as one early legislative report did, two questions. First, How much will the legislation stimulate the producer and so benefit the public? And second, how much will the monopoly granted be detrimental to the public? As Judge Walker of the Second Circuit recently summarized, the copyright law seeks to establish a delicate equilibrium. On the one hand, it affords protection to authors as an incentive to create, and on the other, it must appropriately limit the extent of that protection so as to avoid the effects of monopolistic stagnation. The Founding Fathers wanted copyright to be a mechanism by which our democracy would grow and flourish, a way in which our storehouse of knowledge is stocked. Professor Loren goes on to provide an illustration of how copyright law has been used to censor information. She gives the example of David Stowe, who is a professor at Michigan State University. He wanted to write an article about how sexism and racism pervaded the big band culture of the 1940s. And he wanted to illustrate his article with cartoons from Downbeat magazine from that time period. So he went to Downbeat magazine and he asked them, "Hey, can I use these cartoons to illustrate my article?" And they said no. And he was willing to pay them, but money wasn't the issue. They didn't want him to use the articles at all, period, end of story. Now we can only speculate as to why they didn't want him to use the articles, but most people are guessing that it's because they feared that it would portray Downbeat as a racist magazine, and they didn't want to be embarrassed about that. So he had a choice. He could either use the articles despite their refusal of permission, and if he did that he would risk getting sued, or he could leave them out and write the article without the cartoons. He decided to do the latter because even though he probably would have won under the fair use doctrine if this had gone to trial, whenever things go to court, there's always some question. And besides, the only thing that's absolutely certain is that he would have had to spend probably thousands or tens of thousands of dollars defending himself, and it wasn't worth the hassle to him. So he wrote the article without the cartoons. It didn't completely censor him because there was other things he could include in the article, but the article was not nearly as good as it might have been had he been allowed to use the cartoons. So you can see, even under the fair use doctrine, censorship can happen by the abuse of copyright law. And things only got worse with the passage of the Digital Millennium Copyright Act. I want to read once more from Professor Loren. She wrote, "The Digital Millennium Copyright Act seriously impedes the access to copyrighted works and the non-copyrighted elements of those works, thereby threatening the ultimate aim of copyright, the promotion of the progress of knowledge and learning." Now, in the next few weeks ahead, maybe 3-4 weeks, depending on time, I'll be making a series of videos exploring this topic further. I'll cover fair use and the Digital Millennium Copyright Act and how that can be used for the exact opposite of what our Founding Fathers' intention, how it's used to suppress information. So that's something for you to watch out in the coming weeks. This has been the Masked Analyst, under and in.